Hello, everyone. Welcome to the next episode of the UPC Insights. Our topic and our theme today, long-arm jurisdiction at the UPC, recent Court of Appeal, and local divisions of development. And as always, we try to bring you the best guests, and today is no exception. But before I introduce our guests, let me give you some background on Mr. Moritz-M Bloser. Well, let's start with this, sir. He advises national and international clients on all matters relating to patent and utility model law. He specializes in particular in patent infringement and litigation, especially in the fields of mechanical engineering, medical technology, mobile communications, telecommunications, and electronics. The man has no end. And in addition to his focus on patent litigation, including freedom to operate and infringement opinions, Moritz Bloser also advises in contractual matters such as license agreements. Furthermore, he advises clients on analysis of their patent portfolios and the development of individual patent strategies. Ladies and gentlemen, without further ado, the man himself, Moritz Bloser, welcome to the show.
Hi, George. Thanks for having me.
No problem. So, our topic today, the territorial reach of the Unified Patent Court, has been one of the most discussed topics at the UPC in recent months. Within the past few weeks, the UPC Court of Appeals handed down two, not one, but two landmark decisions, and the Hamburg local division has now issued the first major local division ruling that applies that new Court of Appeal guidance. Joining me once again, Moritz, tell us, why does this matter?
Thanks, George. Yeah, indeed. We have three decisions in roughly 1 month. First, the Dyson versus Dreame decision of the Court of Appeal from March 6th. Then the KeeeX versus Adobe and OpenAI, also from the Court of Appeal on March 13. And finally, the Hamburg's final order in the second Dyson Dreame proceedings. So after their first round, they come back to it after the Court of Appeal has put a stop to some things of them. So these three decisions mainly together mark a turning point in long-arm case law for the UPC. So after roughly 1.5 years in which the local divisions have tested how far they could push the reach of the UPC in view of the BSH Hausgeräte judgment, we now have finally some guidance on and one referral to the European Court of Justice, the ECJ. And with this, the first concrete examples on how the local divisions translate this guidance of the Court of Appeal into the practice. And this includes, as mentioned, the self-correcting decision from the Hamburg local division in the second Dyson versus Dreame case.
Okay, so interesting. So before we look at the new decisions, let's set the stage. What do we actually mean by long-arm jurisdiction at the UPCs? To me, it sounds like something invasive or intrusive. What's your take?
Some might say so, especially colleagues and judges from other countries. Was a big topic on the Inter in London in the previous weeks. We discussed a lot about it because, of course, many other jurisdictions are not too happy about the far reach of the UPC and also of the German courts, but we're here to talk about the UPC. So yeah, long-arm jurisdiction, there are really two distinct situations. First, we have the UPC handling the infringement of European patents, or parts of European patents, which are validated not in UPC contracting member states, but in other EU countries like Spain, the United Kingdom, and Ireland, among others. Secondly, the UPC exercising jurisdiction over defendants which are not domiciled within the UPC area. So in particular, companies based in third states as the US, China, and Hong Kong. So both situations are in principle governed by Article 31 of the UPC agreement, which refers jurisdictional questions to the Brussels Recast Regulation and the Lugano Convention. We will now focus mainly on the Brussels Recast. Here, the key provisions are Article 4 on the defendant's domicile, Article 7.2 on the place of the harmful event, and Article 8.1 on the joiner of co-defendants. We will get into more detail with this later.
So the ECJ's BSH Hausgerät, or Electrolux judgment from February 2025, was widely seen as the trigger for the UPC's expansive approach. Could you summarize it briefly, and do you agree with it?
Sure. Yeah, the main gist of the BSH Hausgeräte versus Electrolux decision is first that a court seized at the defendant's domicile under Article 4 of the Brussels recast, so retains jurisdiction over a patent infringement action even where the patent is validated in another state. And even there, the defendant challenges validity by way of defense. So this means if I have a German defendant,
Okay.
I can assert maybe the Irish part of an EP patent against him before the UPC in Germany or also before a German court.
Okay.
And so this also means this is also the case even if he is challenging the validity in the other country, so in Ireland. So the validity remains with the court of the state of registration under Article 24.4. So
Okay.
in our example, Irish courts, but the infringement court can still decide the infringement issue. So, and where the patent concerns non-EU states, the court may even take a view on validity for the purpose of resolving the infringement claim. So for non-EU part of patent parts, the reach is even farther regarding invalidity. So for the UPC, that opens the door to the longer jurisdiction over non-UPC patent parts, at least where there is a proper Article 4 anchor in a contracting member state. So if you have an anchor defendant or defendant domiciled within the UPC territory.
Okay, then how did the UPC's first instance courts then apply BSH to that?
So yeah, the BSH decision came out at the beginning of last year, roughly. And after this, there have been numerous first instance decision of the various local divisions of the UPC. Here, two patterns quickly emerged from these first instance courts. The first is the classic BSH scenario. So we have a defendant domiciled in a UPC contracting member state, which is sued, and the claimant asserts the infringement of patents in non-UPC states, such as Spain or the United Kingdom. Okay. Like I said, this follows directly from Article 4 in conjunction with Article 71b(1) of the Brussels recast. Secondly, we have the use of Article 8(1) of the Brussels I recast. This is where a UPC domiciled defendant serves as an anchor for co-defendants which are domiciled outside the UPC territory. So here, for example, the Hamburg local division in its first Dyson versus Dreame proceedings then went a step further and extended a preliminary injunction, so preliminary measures, PI proceedings, to Spain against a Hong Kong company and against a German EU authorized representative. This is exactly the kind of long-arm exercise the Court of Appeal has now sent to Luxembourg with the referral, to the ECJ.
Right. So basically, it seems to me as if the UPC is influencing outside of the UPC jurisdiction how things function. Is that correct to say, or is it kind of a guideline, or is that?
So yeah, they have several questions are asked, and they will give us further guidance, hopefully.
Yeah. Okay. So let's stay with the first Dyson versus Dreame for a moment. What was the Hamburg first instance ruling?
Right. So, like I said, Dyson applied for provisional measures against 4 defendants at the Hamburg local division. So the two most relevant defendants for our jurisdictional issue were Dreame International from Hong Kong and a company called Eurep GmbH, so German Limited, based in Germany. Eurep was Dreame's EU authorized representative under the General Product Safety and Market Surveillance regulations.
Okay.
So that role might be worth for a brief explanation. If a non-EU manufacturer wants to sell products on the EU market, it needs an economic operator established here within the EU that can take on certain compliance tasks. So this, what we call an authorized representative, serves as the contact point for the EU and national market surveillance authorities. It holds the technical documentation, ensures declarations on conformity, and also cooperates with authorities when necessary or when any risks would arise.
Okay.
Crucially, what's here important is this authorized representative does not import or distribute or sell products itself. Its role is purely regulatory. So the distinction is very important for what we will discuss later.
Okay.
So further, Hamburg granted a UPC territory injunction against the 3 operating entities and also against the extended this injunction also to Spain against both the Hong Kong Dreame International and the Germany authorized representative EUREP. So this means the local division reached into Spain on the basis of the third state, Hong Kong defendant, combined with the anchor German EU authorized representative defendant.
Okay. Okay.
And that is precisely the question the Court of Appeal has now referred to the ECJ, to the European Court of Justice.
Interesting. So now to the Court of Appeal. Now it gets good. Walk us through what the Court of Appeal actually did in the Dyson versus Dreame on the 6th of March, 2026. That's pretty interesting to me.
Yeah, absolutely. That's a decision we waited for some time. So here the Court of Appeal issued 2 parallel orders on the same day. In the first, in a substantive order, it upheld and extended the preliminary injunction for the UPC territory, but dismissed Dreame's appeal on claim construction infringement and also further allowed Dyson's appeal regarding newer Dreame products. So it actually expanded the injunction to new products.
Okay.
But so far for the UPC territory, the injunction against Dreame International in Hong Kong was held up. It stands further. So for 2 specific parts of the case, however, the Court of Appeal stayed the proceedings. So this was first the action against Dreame International to the extent it relates to Spanish territory, so the long arm against the Hong Kong company. And secondly, the entire action, so also for the UPC territory, against the authorized representative EUREP. So the which the party not really infringing in itself. So for these 2 parts, the Court of Appeal made a referral to the European Court of Justice, which was the first ever referral from the UPC to Luxembourg.
Okay, that sounds
which also a very new thing and long waited for.
Did you expect it at this juncture?
Expected was definitely in the realm of possibility that something like this would happen. Yeah.
Okay.
But you never know when the court feel they still can decide on themselves or they need to refer it. So their first instance might most often be not to give a referral to the ECJ, but decide themselves because they feel that they also know the answers often. But here, completely correctly, they referred.
So, and is this the very first referral from the UPC to the ECJ, and then what are the questions?
Yes, like I said, it's a first ever UPC referral in almost now 3 years since the UPC started in June 2023. So the referral covers basically 4 questions, and they really come down to 2 practical issues.
Okay.
So the first issue is whether the UPC can use Article 8.1 of the Brussels to draw a third state defendant into proceedings concerning non-UPC EU country. So in our case, can Dreame International from Hong Kong be sued at the UPC for an alleged infringement in Spain, outside the UPC, simply because its German EU authorized representative is also a defendant domiciled in Germany. So the Court of Appeal sees a genuine tension here. Under Article 8.1, claims must be so closely connected that there is a real risk of conflicting judgments. But the position of an alleged direct infringer and that of an authorized representative who only handles regulatory compliance are arguably the same situation of fact and law, and not the same situation of fact and law. And that is the standard the ECJ set in a previous decision in Solvay versus Honeywell back in 2012. The second issue is whether the UPC can grant cross-border provisional measures extending beyond the UPC territory. So here into Spain, when the same products are sold across Europe through quasi-identical websites. Linked to that is a more substantive question, whether an EU authorized representative who provides only regulatory services, but not actually infringing, and has no actual control over whether the products are sold, can really be regarded as an intermediary against whom the injunction may be granted under the enforcement directive.
Yeah, that's interesting in itself. Yeah.
Yeah, so this means the ECJ's existing case law on this topic on intermediaries had concerned services that practically enable infringement in fact, not mere regulatory compliance as an EU authorized representative. So far, the referral to Luxembourg to draw the line between those situations made sense.
Yeah, before I get to the next question, is there a way to enforce a judgment? Is this, or does the person infringement or being sued have a way to appeal this, or will they take it seriously from the UPC long arm jurisdiction? Or is that something?
This would be a whole nother topic.
Okay, gotcha.
So yeah, that's the problem.
Gotcha.
The problem is you might have an injunction in Spain against the Spanish part of the patent against another company. It might be a problem to really enforce this in UPC injunction in Spain.
Okay.
But here but at least you have companies, defendants which are domiciled in Germany, so might be able to put pressure on them on other means. But a real direct injunction, enforcement of the injunction could become difficult. This is definitely a topic which we will see how it will resolve in the future, how other countries will handle that and will accept or
right.
Yeah.
The outcome.
These decisions.
Then why is this referral significant beyond the immediate case?
That's a good question. Here, two reasons stand out. First, it confirms that the UPC sees itself as a court firmly bound by EU law. So this was known, but it's now we have real proof that they accept or seek also help from the European Court of Justice.
Right.
So the Court of Appeal asks itself the standard ECJ question for referrals, which is the answer either obvious or already settled by existing EU case law? It then concluded that neither was the case here in our situation, and that is exactly when a referral becomes necessary. Secondly, the substantive point raised will definitely define the scope of the UPC's long-arm jurisdiction for the years to come. So if the ECJ answers question 1 in the affirmative, Article 8.1 will become a quite powerful gateway for plaintiffs to bring third state defendants before the UPC and also for non-UPC EU states. If the answer is negative, the long arm shrinks significantly.
Yeah, I guess so. So let's turn to the KeeeX versus Adobe and the OpenAI from, I guess OpenAI has just had a recent fight with our friend from the United States, Elon Musk, which I think Elon lost, I'm not sure, from 13th of March, 2026. What was this dispute about?
So yeah, this is the other big appeal case here. KeeeX is a French company, and it sued Adobe and OpenAI entities. And so entities from both based in the US and in Ireland, among some other defendants, but which we'll keep out for now.
Okay.
So the key jurisdictional fact is that none of the defendants are domiciled in a UPC contracting member state. So all are from outside the UPC territory.
Right.
As you know, Ireland has not ratified the UPC agreement yet, and is therefore not a contracting member state. In the first instance, the Paris local division had nevertheless accepted its jurisdiction, also including for the infringement of the Swiss, Spanish, British, Irish, Norwegian, and Polish parts of the EP patent, all on the basis of Article 7.2 Brussels I recast. This means the place where the damage occurred or threatens to occur.
Okay.
This anchored by the accessibility of the defendant's website in France.
Okay, this is interesting. So this brings me, before we get to the next question, I know it's without going off team, is it kind of like a NATO thing? The UPC is in all these different nations are on the verge of becoming apart, as you say, like Poland,
no, this
Ireland, and so yeah.
So all EU member states were free whether to join the UPC or not. So I think currently we are 18 countries which are part of the UPC. But some decided not to join. So the most prominent, of course, the UK during Brexit, they went out. They couldn't join anymore. And Spain and Poland, for example, they from the beginning decided no, they do not want to join the UPC. They had different reasons, but they said no, we don't want this. It's not for us.
Okay.
And Ireland, for example, Ireland will join, and they have accepted the agreement in general, but they have not ratified it finally within the country. So they need to do the last step before
Gotcha.
they can join. But this will probably happen in the next year or two, probably.
Gotcha. Interesting. So the next question, and the Court of Appeal disagreed?
Indeed, it did. The Court of Appeal held that where the UPC's jurisdiction rests on Article 7.2 of the Brussels, that jurisdiction is strictly territorial, so through the territory of the UPC. The Court of Place, where the damage occurred or threatens to occur, has jurisdiction only for damage arising in its own territory, so not outside the UPC territory. So the Court of Appeal anchored this in the ECJ's settled case law. The Paris local division in the first instance had relied on BSH Hausgeräte decision, but extended this, which was more Article 4, extended this to now Article 7.2, so the jurisdiction of non-UPC states. But this was flat out rejected by the Court of Appeal because it is based on an incorrect interpretation of the law in their understanding. So, like I said, BSH Hausgeräte addresses Article 4 jurisdiction at the defendant's domicile and not Article 7.2. The two cannot be just blended as the first instance local division did, and Article 7.2 simply cannot ground long-arm jurisdiction over non-UPC states.
Okay, interesting. So then let's now move to what is in many ways the first real test of how local divisions absorb this new Court of Appeal guidance. The Hamburg local division issued its final order in the second Dyson versus Dreame proceedings on the 7th of April, 2026. Set the stage.
These second Dyson versus Dreame proceedings involved a new attack product and 5 defendants. We had Dreame International from Hong Kong again, Dreame Technology from Sweden, Dreame Technology from the Netherlands, TechPhone from Germany, and Cellcom as the UK distributor. So the Dutch entity plays 2 roles. It is first the importer of record for all shipments into the European Union, including Spain, and it also acts as the EU authorized representative, as we said before. But here it's a Dreame company.
Okay.
Not a foreign company. So the applicant sought injunctions covering the UPC territory, as well as Spain and the United Kingdom, including Northern Ireland.
So then what did the Hamburg panel actually do, and where did it correct itself?
So Hamburg makes 3 important moves, building clearly on the ground of appeals guidance. First, on the basic jurisdiction. Hamburg corrects its own earlier position and now holds that the UPC functions as a single court with a territory covering all contracting member states. So this means the UPC has jurisdiction over any defendant domiciled anywhere in the UPC system, and Hamburg falls with this in line with both the Court of Appeal and also with the former decision of the Hague local division at this point.
Okay.
The second, on Spain. Hamburg uses Article 8.1 with the Dutch entity as an anchor, but carefully distinguishes this from the first Dreame and Dreame case. So here the Dutch entity is itself alleged to be a direct infringer, not just an authorized representative, because it imports the products into Spain, and Spanish law treats import as direct infringement.
Okay.
So here the Dutch anchor has a substantive role and not just a regulatory one. And this is precisely why the Court of Appeal's referral to the ECJ does not require a stay for this case. So finally, for the UK, here Hamburg draws a clear line and denies an injunction. The applicant wants to use the Dutch entity also as an anchor for the UK distributor under the joinder rule, Article 8, and Hamburg rejected that. The reason is quite straightforward, actually. The requirements of the General Product Safety Regulation apply only in Northern Ireland and are not there to protect the UK market. So it's an EU regulation.
Right.
And they exist solely to facilitate the trade between Northern Ireland and the Republic of Ireland and to avoid a hard border. From a UK perspective, the Dutch authorized representative plays no meaningful protective role. And the UK distributors simply cannot be expected to foresee being dragged into UPC proceedings just because a Hong Kong manufacturer has appointed a Dutch entity for regulatory compliance. So this connection is just too remote for the Hamburg court.
Oh, very interesting. So how do these three decisions fit together? And what is the current state of the long-arm jurisdiction at the UPC itself?
Right. Okay. Let me bring this all together. The BSH style long arm based on Article 4, so where the defendant is domiciled in a UPC contracting member state, and the infringement is asserted for a non-UPC violation, so for example Spain, remains intact and has been expressly confirmed by both the Court of Appeal and now also the Hamburg local division. The UPC treats itself as a single jurisdiction with a universal jurisdiction under Article 4 over any defendant domiciled in any contracting member state.
Okay.
Article 7.2, so where the damage occurs, is firmly territorial after KeeeX decision. So plaintiffs can no longer use websites accessibility to reach non-UPC states. And now the Article 8.1, the joinder works, so the anchor issue is where the anchor is itself a direct infringer with a substantive role in the alleged cross-border conduct, the infringing acts, as Hamburg accepted for the Dutch importer, but it does not work where the anchor's connection is merely regulatory and unrelated to the protective purpose in the target state. This is why Hamburg refused the injunction for the UK in the latest decision.
Makes sense. Yeah, okay.
So at the most expensive theories, Article 1 reaches into non-UPC EU member states. We are a UPC domiciled intermediary, the anchor, and Article 71b(2) on as a basis for cross-border provisional measures, so PI proceedings. These are suspended pending the ECJ's answer in the Dyson referral. So the questions refer to the European Court of Justice. Okay. What is also striking, actually, is how quickly the local divisions have absorbed all of these Court of Appeal decisions. So after the second Hamburg decision, we now have also a decision from the Paris local division, which applied also the KeeeX strictly to another BMS Innovations versus BYD case on April 14th, rejecting jurisdiction over the UK defendants whose acts were actually only limited to the UK and not UPC territory. And also we have a decision from the Milan local division in Dyson versus Alpine Stars on April 21, which accepted Article 8.1 jurisdiction over Spanish co-defendant, but then stayed the Spanish part of the action because validity proceedings were pending in Spain. This was quite surprising, but because they wouldn't need to do that, but here decided to do. So yeah, the consolidation of at the Court of Appeal level is already being translated into the first instance practices.
Well, that sounds pretty interesting. Before I get to the next question, because I'm always curious, this is the Hamburg UPC division. Normally, I hear all the time about the Dusseldorf UPC courts and the Munich courts. Why do you think it's Hamburg who made this decision, as opposed to the other two?
This is because this first instance, Dyson versus Dreame, was in Hamburg. The plaintiff at that time decided to go to Hamburg. Hamburg has a reputation to be maybe sometimes more easy. This was PI proceedings, preliminary measure proceedings. So not normal long proceedings on the merits, but PI proceedings. And here Hamburg has a good standing to be a good venue for PIs. Maybe this was the case, the reason why they went to Hamburg. And now Hamburg had, after the Court of Appeal, had to deal with this again. So it was Hamburg again.
Yeah, okay.
Yeah.
But it's interesting. But it's interesting how you can choose your courts to see which one fits your situation. So the final question is, what is your outlook for long-arm jurisdiction at the UPC going forward?
So keeping all this in mind, I think the long-arm jurisdiction at UPC is very much alive, but it is probably entering a more, let's say, disciplined phase. Right. So the first instance case law was, quite frankly, very expensive after BSH Hausgericht. So the first instance courts reached very far. Yeah, they took a very long arm for sometimes. Yeah.
Right.
And now the Court of Appeal has now sent two clear signals. So where jurisdiction base is too thin, it will pull the reach back, as it did with Article 7.2 in the KeeeX decision. And where the issue is genuinely open, it prefers to obtain guidance from the European Court of Justice rather than improvise its own jurisdictional map of Europe, as it did with the Dyson referral. So the best way to put it is maybe this: the long arm of the UPC has not been cut off, but it has been at least shortened and placed under closer judicial supervision. But it's actually still there and still usable.
I think we're going to have a lot to talk about in the future.
Yeah.
So listen, first of all, Moritz, I would like to thank you for taking the time out of your busy schedule to join the show, and also for going through a very detailed walkthrough. And to our listeners, thank you for tuning in. And we'd also like to thank you for joining us for another episode of UPC Insights. We look forward to bringing you all the latest developments in the world of UPC Insights. Feel free to check out our past shows on YouTube, Instagram, LinkedIn, and our personal website at Meister & Bolta. And also, they're more relevant than ever, or check out our UPC shorts with the legendary Tillman Frank. My name is George Walden. On behalf of the man himself, Moritz, Melchior, Bloser, thank you for joining us. Until next time, auf Wiedersehen.
Thank you very much, George. It was a pleasure, as always, being with you.
Looking forward to seeing you again.